everyone. Welcome to the webinar. We are very fortunate to be here today with Beth Schroeder. Hi, Beth. How's it going?
Good.
Thanks for joining us today, and thank you everyone else for joining us today. Beth is going to be sharing some very important March 2022 legal updates for your business. She's a preeminent labor and employment counsel, California labor law expert as well. Beth is also a partner at Raines Feldman, as well as the CEO and co-founder of Kender, the anonymous employee app that promotes secure and discreet workplace communication. And Beth will be chatting a little bit more about that later today. So today we're going to be chatting about some important March 2022 California labor law updates, other important updates in the space. My name is Stephanie, and I work with Cannabusiness, and Cannabusiness helps business owners, dispensary owners grow and scale their operations by simplifying payroll, HR, and workforce management, things like scheduling and time tracking from one easy-to-use platform designed for business owners. And Cannabusiness also integrates with leading POS systems, offering an end-to-end solution that gives you the ability to have transparency into your business like never before. And one of our main goals is to really help business owners succeed and make running their business easy and more streamlined and help them do it in a compliant way. So that's why we want to bring the spotlight onto Beth, who is here to also help business owners do the same thing with her legal expertise. And a quick introduction into Beth, and I will give her the floor after this as well. But Beth is a preeminent labor and employment counsel, and she has over 3 decades of experience in representing employers in all aspects of employment and labor law, including the defense of employment-related lawsuits involving wrongful termination, harassment, discrimination, wage and hour issues, and related claims, both individual and class action. And Beth is going to be sharing important updates. I know some are really recent that are March specific as well. And without further ado, I'm going to hand it over to Beth to share some of those important pieces as well and tell her a little bit more about herself. Over to you, Beth.
Great. Yeah, thank you, Stephanie. Appreciate the intro. And yes, I've been doing this for, gosh, it's going to be going on 4 decades, way too soon. So probably go on to the next slide. We'll start getting right into the meat of this. Yeah, we'll start off with, with what's going on this year. It's been a relatively quiet legislative year, except for what they've been doing to us, COVID related, sort of pushing out laws, pulling back laws, pushing out and pulling back laws. And then we'll sort of touch on a little bit of how to just keep businesses out of trouble generally, what's going on with what we're seeing, litigation trends, and just a little bit of best practices, and along the way. One of the reasons that I've been doing work with push operations since we met right before the pandemic. I like the fact that they are a very proactive company, that they do a lot of things to keep employers in a good space about working with companies. They've been very proactive during the pandemic on doing temperature and safety checks and symptom checks, but also just in keeping track of breaks, which in California is such a big issue. No matter what kind of employer you are, we're always hit with these pesky break issues. Obviously, in industries like the ones I deal with so often, such as hospitality, but even we're seeing these claims being made in white collar industries now. These PAGA cases, which we would love to see go away when we see Supreme Court hear argument in the Viking River Cruises cases in another week or so, but class actions and PAGA cases, are still creeping in, and the meal and rest breaks are still the most common claims we see, even on an individual basis. So we'll talk a little bit about that as well. Okay. Okay, so legal updates, like I said, it wasn't a huge, big year legislatively as far as changes made. I think, the legislature was really busy with COVID. But remember that in California, we have a checkerboard of ordinances, different counties, different cities making their own changes. We saw a real flare for that with COVID, everybody doing their own thing still with regard to drilling down on everybody, every municipality having to flex its own muscles. So again, everybody has their own individual minimum wage. We saw, for example, West Hollywood, which has its own minimum wage, sick leave. West Hollywood will be the only municipality, I think maybe nationwide, to have its own vacation rules, which will get rolled out in July. But in January, we saw a plethora of minimum wages go up in California. We will see another bank of those laws go up in July. So for many of you, you know that 5 or so years ago, we had a trend of minimum wage laws go into effect in California. Those technically hit their peak at the $15 an hour law, in many of them as of last year, but then they go on to the tracking against the CPI. So for example, in Los Angeles, we hit the $15 an hour mark in Los Angeles city and county, but now effective July 1, our minimum wage goes to $16.04. So now you get these random minimum wages. Many of them in Northern California went up January 1. So you've got a lot of very strange minimum wages throughout California. I forget how many there are, but you know, something like 30 different minimum wages. So depending on where you are, sometimes across the street from you, you may have a different wage, minimum wage, or down the street from you. And you absolutely have to know where you are. I had one client who operated for about 10 years before they realized that they weren't in the city they thought they were in. They were actually in the city of Los Angeles because the street they were on was a different street than they thought they were in. So city lines can change, borders can change, and you have to know exactly where you're located depending on what minimum wage you are, what sick leave applies to you, and what employee counts you are. For example, Los Angeles counts the total number of employees you are. Santa Monica counts the number of employees you have in Santa Monica. So knowing all these laws and knowing what laws apply to you is very important, because some of these laws have, for example, daily penalties that apply if you don't comply with them. And for example, the sick leave laws, you have to write down how many sick leave days you have, and that has to be on your pay stub. Failure to put that on your pay stub is a violation of Private Attorney General Act, that's PAGA, and those are very expensive penalties. So besides that, we got a small change to the Family Medical Leave Act, which says that now employees are entitled to a leave of absence to take care of their grandparents and parents-in-law, as well as serious health conditions of parents, siblings, children, and themselves. So, and remember, as of last year, the California Family Rights Act was extended to cover employers as small as 5 or more employees. So these family medical leave laws apply to almost everybody in California. They're very small employers are governed by this. Keep that in mind. So okay, go ahead. Next slide. No, go back to COVID pay. Yeah, so California COVID pay. So the COVID pay has been obviously slowing down. Most of California has rolled back a lot of their COVID restrictions. Masks are gone everywhere in California. Vaccine restrictions or checking is going back, but we have COVID pay that has returned in California for another year. So we had California COVID pay for 20 and 21. And because of the Omicron surge, California decided midway through February to make a return of California COVID pay. But California COVID pay looks a little different in California this year than it did in 20 and 21. So in California, we have California COVID pay. We have 2 banks of 40 hours each, and they work a little different about how you get them. You can require a test for your 40 hours, And if the employee is still positive after the second 5 days, and they can access the second bank of 40, it works similar to last year's California COVID pay. The employee can get it for their own COVID, if they have COVID themselves, or if they're caring for a family member. They can also get COVID pay if their child's school is closed. I don't know how much we're going to see that now, unless we get another huge surge. They also can get COVID pay if they're quarantining, but remember the quarantining rules have changed. So again, hopefully we're not going to see a lot of COVID surges anymore, but we are still seeing some COVID pay claims. The big issue with California COVID pay is that while this went into effect middle of February, it is retroactively effective to the beginning of January 2022. So employers, if you have not already, you do have to make this public. So there's a poster that California put out when California COVID pay went into effect back in February. So if you haven't yet done this, you should post the poster. You should distribute information about California COVID pay, so that if you had employees who had COVID back earlier in the year in January, they can still make a claim for that COVID pay, and you as the employer would have to make that COVID pay available to them now, even if they had COVID pay or had COVID earlier in the year. Obviously, COVID pay is still available to employees between now, January 1st of this year, and it will sunset as the other COVID pays did sunset in September of 2022, end of September 2022. So it will be available for whatever surges we have coming to us between now and then. Unlike the California COVID pay in the past, where we had to have a running total of what California COVID pay was available to the employees, California COVID pay of 2022 only requires that you put it on the paycheck what has been used so far in 2022. And if an employee has not used any California COVID pay in 2022, then you put down 0. There's a formula that you have to use to show if you have a part-time employee and you want to figure out what the average is that they've used. And if you have employees who have variable pay, there's also a formula about how you figure out the variable pay. All of that is in the FAQs that's available under California COVID pay in the California Labor Code. So if you have any questions on that, let me know. I'm happy to walk you through any of that. I just did a talk on this for the Santa Monica Chamber of Commerce last week, but I don't want to spend the whole talk on that. I just want to remind everybody the most important thing is to post the poster and to remind their employees that that is available to them. California COVID pay is not, you do not get a tax credit against your taxes like we did with the federal FFCRA 2 years ago. We had hoped we would, that was sort of the rumor, but we don't. We're sort of putting pressure on our legislators to maybe pass that through one of their budget changes this year. But right now, you just treat it like regular sick pay. And by the way, another reminder, like I said, sick pay and California COVID pay both have to be on your wage stubs. Sick pay, you have to have a running total of what's available to your employees. COVID pay, like I said, just has to show on there what's been used so far this year. Failure to do either of those two things, like I said, is a violation of the California Labor Code and can put you at risk for a PAGA claim. Those PAGA claims can be very expensive. So make sure, if you haven't checked lately, that you are keeping both of those things on your pay stub. There are about 10 different requirements of what need to be on a wage statement in California. Failure to do any of those things can set you up for a wage stub violation. Wage stub violations can be as much as $4,000 per employee per year in California. Start doing the math about how many employees you have, and you can imagine how expensive these PAGA suits can be just for that one claim, plus attorney's fees. Okay, next. So legislative trends, if you haven't already heard me say a few times during this talk, mention the word PAGA. I think by now everybody knows what PAGA stands for, but I will spell it out for you very quickly if you haven't. It's one of my least favorite things about California. So quick education about PAGA. PAGA stands for the Private Attorney General Act. It's located in Labor Code Section 2699. It was a law that went into effect, signed by our former governor, Gray Davis, literally as he was being thrown out of office back during our first attempt to try to kick out a governor, which that attempt was successful, and we had Governor Schwarzenegger come in on his heels. So the Private Attorney General Act, very quickly, is a law that essentially has attorneys act as private attorney generals. The thinking back then by Governor Davis was that we didn't have enough people in the state to look out for the interests of employees, and therefore he was going to dub attorneys to go out and try to find employees who would bring these claims of violations of that employers made, because he thought employers were mistreating employees, and that they would go out and they would bring claims on behalf of all the aggrieved employees at that company. And if the employee was successful, that they would find wage claims, and these would be wage claims that employees previously couldn't bring because they were just for the penalty portion. In fact, they were not for the damages portion. You don't, in a PAGA claim, you don't bring claims for actual wages that are lost. It's just for the penalties. So the wage claims can still be brought in a different claim for like the class actions. This is just the penalties. Keep in mind that when the labor commissioner used to go after employers for violations, they rarely awarded these penalties. It was only in the most egregious of cases. So these are claims that are just chasing like punitive damages, just chasing the worst penalties that would be avoided. And they would go after lawsuits looking for just the penalties. So they would go after just the penalty portions to punish employers who were bad employers. And they would bring these lawsuits looking for just these penalties, and they would ask for them, the penalties for so many payroll periods. And then when they were successful, the money would go to, they would get this pot of money, and 75% of that pot of money would go to the state of California. 25% of that pot of money would go to the employees, all the wronged employees at the company, even if they weren't in the same group of employees that that employee worked at. And then all the attorney's fees would go to the attorney. So attorneys started bringing these claims. At first, nobody really thought about doing it, but then it became this boondoggle because attorneys said, well, this is a great idea. And they go find these employees and they would bring these claims, sometimes having nothing to do with the employees who they were talking to. They would just be claims for any employees who'd worked at the company, and they would just throw everything at the wall for anything that could possibly have gone wrong. And that's how this started. And the judges just went wild with it. They basically just let people throw everything at the wall that could possibly have gone wrong. And the problem is that these cases are so huge that you can't fight them because they're worth millions and millions of dollars. And, fighting them is ridiculously expensive. And the judges have basically said you can't settle them because they don't belong to the employee, they belong to the state of California. So we can't buy them off, we can't settle them like we can in normal cases. We can't possibly, cure them all because they throw absolutely every violation you could possibly imagine at them. And they're ridiculously expensive. And by the time you get to court, the courts knock them down to a reasonable amount, but because they're so expensive, you can't settle them before you get there and you can't litigate them. So this is the problem with PAGA cases, and they don't have the procedural protections that class actions do, where you say, well, let's find out what's really there before you move forward and what's really an issue. They literally put everything in these letters that it's possibly, there. So it's obviously maybe there was a good intent there to begin with, but they're out of control. And of course, the state's made a ton of money on them, and these attorneys have made a ton of money. And what ends up being put into the employees' pockets is very, very little. So you can see where my proclivities lie on this, because I don't think the interests are being served at all. But the good news is that we're going to have a little bit of a way to fight these, I hope. First of all, there's a proposition that's been put forward for the November ballot that would basically put the power back, take money and put it back in the power of the state to look into these violations, which is really where it should belong anyway, because they're the ones who know what they're doing with it, and that's really where it should be, put the genie back in the bottle. And we also have the possibility that arbitration agreements, which is what we use to fight class actions, we'll be able to use that as a weapon, and we'll find that out, and I'll talk about that in a minute. Meal and rest break claims are still the biggest driver of these PAGA suits. And, again, that was one of those things that was introduced again by Gray Davis when he came into office. Meal and rest break claims, it's part of what the wage and hour laws always had, but they didn't have the penalty portion to it. That came in when Gray Davis came into power as part of AB 60, and again are used just as sort of this weird thing in the lawsuits. We just have to just make sure that we're watching how our employees are working. And misclassification cases, it sort of sneaked in right under the pandemic, but AB 5 came into effect in 2020. That's the law that basically redefines how we define, independent contractors. And a lot of people missed that because it came in under the radar as the pandemic was hitting. But that was sort of the death of the gig economy in California. That was why we got Prop 22, which was the fight against the Uber, that Uber brought in response to it. But especially for those in the entertainment industry, they're just trying to ignore AB 5, but it's out there. And people need to remember that if you're trying to use independent contractors, unless you have an exception under AB 5, you're going to be dead in the water under the statute. So just be careful that you're not doing business as usual if you're trying to use independent contractors, because it is not business as usual. There's a whole new world out there with that. Next slide. Okay, so this is a brand new law, and a lot of people missed it. But as much as we rely on arbitration, and I know that there are several clients of mine on this call, so you all know because you have my handbook that we are big believers in arbitration agreements. And the biggest reason I'm a believer in arbitration agreements is because we have class action waivers in there, and class action waivers will stop your class action lawsuit. And if we're lucky, the Supreme Court will hear the argument of the Viking River Cruises case next week and will apply that class action waiver and shut down PAGA cases. You've just heard me do my number on PAGA cases and why I hate them so much, because PAGA cases need to die a slow death. So, a lot of people, I have a lot of friends who do plaintiffs work, talk to me about why they dislike arbitration so much and why they feel it's unfair to employees in court. I think if the court system worked better, I think if it worked fairer to employers in California, I wouldn't be so opposed to arbitration, to the jury system. In fact, arbitration to me has gotten very expensive. I think these arbitrators, because they know we employers like to use them, they've gotten very expensive. They charge for every little hearing, and some of their rates have gotten crazy. So I'm not even as much of a fan of arbitration as I used to be. I really feel arbitration, the biggest strength of arbitration is the class action waiver and fighting PAGA cases, etc. So when Biden signed this is like the longest title of a law ever, Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. I don't know what they're going to call this thing. There's not even a good acronym for it. It's just this long law. Basically, the law that says you can't have arbitration agreements for sexual harassment cases anymore. That's the law. I'm not even really opposed to this. I don't mind sexual harassment cases being heard in court. Fine. Just give me my class action waivers and I'm fine. If you want to hear sexual harassment cases in court, we'll hear sexual harassment cases in court. To be honest with you, We don't even see that many sexual harassment cases in court anymore. At least I don't for my clients, because I think my clients do a really good job of hearing, making sure that their legitimate sexual harassment cases are handled. Now I say legitimate because we still do see some, meritless sexual harassment cases, at least being threatened. We'll deal with that. Back in the day, I've dealt with my cases, my share of fighting meritless sexual harassment cases. I have defensed some meritless sexual harassment cases in court, and we have as a firm, and if people want to bring those, fine. If you bring a legitimate sexual harassment case, most likely we will settle those, we will handle those, and I have no problem with those. There is still legitimate sexual harassment going on. That I will tell you guys, I see it, I see those claims, I see it happening, and we need to double down on making sure that we as employers handle sexual harassment in the workplace. And by the way, I will say it once and all the time, sexual harassment is not just a women's issue. There is sexual harassment of men that goes on, there's male harassment, women harassment. It is not about necessarily one gender over another, although we still do see more males harassing women because there is still a lot of that imbalance. But that being said, harassment claims are going to end up back in court now. Because harassment claims will end up back in court, we need to deal with that issue. So number one, employers need to make sure, above all, that more than ever, we're doing what we can to make sure that we're dealing with harassment in the workplace. I mean, that has been true anyway. I'm spending a ton of my time just making sure that we're addressing harassment in the workplace for a million reasons. Most of all, I can't believe that we're still in 2022 and I see some of this stuff going on that I see. I mean, I hear about, and it's ridiculous. I have a daughter and a daughter-in-law and a son in the workplace, and some of the way I see people treating people in the workplace is unforgivable. So that's number one. Number two, it is still California law that we have to do harassment training every 2 years. And I still have people saying, I'm not big enough. Yes, you are. It's required of pretty much everybody. So harassment training, and I mean, we can help you with that. We do Zoom training, we do live training. You can do free training through the DFEH. I mean, I'm just going to tell you right now that sitting somebody in front of a cubicle is not your most effective way to do it. But there is some really effective, if you're going to do that, there's some really effective way of doing it. And I can point you in the way of doing some really effective training. But I still think for managers, having people do it either live or, getting a group in front of you, use your chance to get your managers to talk to each other. And then I'm going to do my push for the app that I developed, and I developed it for a reason. I feel that employees don't know how to get a hold of people like you. I hear all the time that they're afraid to reach out, that they feel like their own managers cut them off. They don't know how to do it. So I developed an app that's really easy. It's free to them, so that if they feel like they are, sitting there in the middle of the night and don't know what to do, or they forgot about that hotline that's somehow posted in the middle of their bulletin board, they can pick up their own phone and find you 24/7. And it's really frictionless. And they can just push a button, they can get to you in any language, and they can just text, and it's anonymous, and they can do it with confidence, and they can get you. And that's all it was meant to be. And I just wanted to reach out and have that first reach out be so easy. And then if they, get the comfort level, maybe they can come in person, but I want that first reach out just to be something that makes them feel safe. That's why I invented it, just right there. And then of course, God forbid they don't use it, then it's, it's a defense for them if they didn't use it too. But really, I just wanted to make it something that they, still in this day and age, I see it with my own clients where people didn't come forward in places where they should have felt safe, because I know the owners, but employees still don't come forward, which is horrible, but that's the way the world works. People still just feel like they need to be anonymous. So that's why I invented it. And It's really cheap, guys. It's super cheap. If you're under 100 employees, this thing is $50 a month. I mean, come on, that's like a cup of coffee. So anyway, I feel like in this day and age, you just can't get away with doing something like that. You just have to. People don't want to use phones anymore. Come on, we're in 2022. Anyway, that's my plug for Kinder. But, you know, I think if these cases are going to be back in court, we have to double down on our compliance. That's it. That's no question about it. So very quickly, I touched on this already. Arbitration, like I said, I'm really not afraid of harassment cases being back in court, but I am, like I said, I hate PAGA with every fiber of my being because it's a horrible statute. And what's the background of arbitration is, you know, class action waivers have saved our lives. Class actions are big, hairy, scary beasts because PAGA cases go back a year, class actions go back 4 years, and they're gnarly and awful. But we have this wonderful get out of jail free card because if our employees signed arbitration agreements with class action waivers, and if you don't have one of those in your handbook right now, when you get off of this webinar, you run, do not walk to contact me or someone else about getting one of those in your handbooks because they are enforceable. Don't let anyone tell you they're not. There's that law, AB 51 there, but it's on hold. And it's on hold because the Supreme Court of the United States loves arbitration. I know the government doesn't, but right now the Supreme Court still thinks that the Federal Arbitration Act is the law of the land, and I think it's still going to be. So the Federal Arbitration Act is the law of the land. Congress is making some noise about doing away with arbitration like everywhere in the world, but I don't think that's happening. I think that the Senate is happy with just carving out this hole for sexual harassment, and I think that's where it's going to stay. I think they're like, yeah, we're not going to make arbitration go away everywhere in the world. We've given you sexual harassment. We've given you that little piece. Let it be. So I think we're going to keep arbitration in other employment agreements. And that's why the Supreme Court has agreed to hear this decision in Viking River Cruises. So California dislikes arbitration. This is where the United States Supreme Court and California Supreme Court butt heads. And I love California. I really do. I love this state, and I'm pretty much of a Democrat, despite what you hear me saying. But this is where California and the United States Supreme Court diverge. California doesn't like arbitration. And they came out with this case in 2014 that says, yeah, because California has a stake, like I said, in the PAGA cases, we're not going to let arbitration agreements stand because California gets a piece of those. We're not going to let class action waivers stand. And that's been the law of the land since 2014. We'll let class action waivers stand for everything else. The Federal Arbitration Act preempts it, but not so fast with PAGA. PAGA cases get a little break with class action waivers. And that's how we've been able to, you know, have all these cases. So along comes all these new conservative judges on the Supreme Court, and they issued this case in 2018 that basically says the Federal Arbitration Act preempts everything. And now people in California have asked the United States Supreme Court to take another look at the California Supreme Court case and say, what about PAGA? Don't you think that it should be preempted as well? And so the new federal Supreme Court, which has got a lot of conservative judges on it, said finally, yeah, maybe you're right. So it's going to take a look at next week on the Viking River Cruises cases, another look at the California Supreme Court's decision, and they may overturn it. They will probably overturn it. And if they overturn it, our PAGA cases are going to come under attack, and they may be under the umbrella of the Federal Arbitration Act. And if they are, all those arbitration agreements that I'm having all you people sign in those handbooks are going to be good to go, and they're going to be able to take out our PAGA cases, which is going to be, I'm going to get a happy dance going on. So that's a big deal. Like I said, I'm not a big fan of arbitration just in general, but when they cut down PAGA cases, yeah, like I said, I can't stand PAGA cases. They're just not good for anybody, at least not for you guys. So AB 51 was a law that came into effect around the same time AB 5 did. Don't get them confused. AB 51 tried to take down arbitration altogether in California, and it met the same fate that other cases did, and said, nope, we got that FAA problem. You know, the Federal Arbitration Act, those people up in the Supreme Court there, they don't like that. They think FAA, that's that big, heavy, hairy beast. And FAA takes down most statutes, except for like stuff that the state of California has a say in. But AB 51's on hold, and I think by the time the Supreme Court flexes its muscles with Viking River Cruises, it's going to pretty much remind everybody that I think AB 51 is probably going to go down too. So I really think that we're going to lose AB 51. I think that the arbitration will stand in California as it does now. And I think and hope and pray that Viking River Cruises makes it clear that we'll be able to use our class action waivers against PAGA cases, and all will be right in the world, but we'll know a little bit more by the middle of this year. Anyway, in the meantime, keep putting arbitration agreements in your handbooks, keep having your handbooks signed by your employees until we tell you otherwise. And if you have any question about that and you need an arbitration agreement or your handbook reviewed and you're not a client of mine currently, send your handbook our way. Happy to take a look at it. And I will keep putting those handbooks out with arbitration agreements in them until they tell me I can't, because I think that we are going to have celebrating to do this year, fingers crossed. So I think this is my last point. The Great Resignation of 2021, I believe, is continuing into 2022. My sense of it is that employees and people in general are still, I just had a call from a client on this yesterday, a little fragile, a little, people are still a little emotional because everyone's coming out of this pandemic still. And you think that the world is back to normal, but it's not quite. You know, even as of last week at the BAFTA Awards in London, they had a huge super spreader COVID event. And it could be heading to the Oscars this week. I don't know. My daughter-in-law is going to be attending and she's staying with me. So fingers crossed that it's not coming here. But, you know, I'm not sure we're out of it. And I think people are still recovering and our office is reopening, but things are just not quite there. People are still a little shaky and emotional and fragile. And I don't think that we're in a place yet where we can just say, hey, it's behind us and everything's back to normal. And not to mention that we, you know, have this war going on in the Ukraine, which I think is, at least for me, I know is troublesome. So I think, you know, before we just sort of, you know, we have people in our lives have, you know, are still having meltdowns. A lot of us have lost people for whatever reason. We're still in recovery. I was trying to explain this to my daughter. My daughter, some of you know my daughter. She's 30 and she has autism and she has this lovely way of just saying whatever is on her mind. And I was explaining it to her and she says, it sounds like PTSD, Mom. Yeah, it does sound a lot like PTSD. I think that's how a lot of us feel. Just treat the people in your lives with a little bit of extra grace and yourselves as well. So I think that's kind of where we all are going to be in 2022, just sort of still in recovery. It's still a little hard to hire. When we find good people, sometimes they turn around and leave right away. I'm talking about employees, but you know, people in general. Someone recently told me that they started dating someone and he just ghosted her. And I said, you know, that's just the story of 2022, I think. But we're going to get there as a nation, as a world. I just think we have to just take a lot of extra deep breaths. I have a client who has an axe throwing company. And then we're also doing meditation classes in our office. Actually, we're doing one tonight. So I said, maybe we do axe throwing followed by meditation. And that feels like maybe what 2022 needs. So throw some axes, then do some meditation, and then we'll get back on the right track. Next slide. Is that it?
I think so.
Good, that's a good note to leave it on. Axe throwing followed by meditation.
Yeah.
I figured that's kind of where that kind of sums it up, right? I was
Nothing-
talking about my axe throwing client. I said, I think that's exactly where it leaves us. Axe throwing and meditation.
There's nothing left to say. No, that
Oh,
is.
that's kind of it. By the way, my excellent client, I mean, I honestly said to them, I said, I think we should sign everybody up for that. I think it's a fabulous idea.
Oh, 100%. I love that. I love what you were saying. And it's so true. It's the combination of like the frustrations, but also just like having to recenter, reground, and yeah, just kind of being aware. I like what you were saying in terms of like things are not the same yet. Like it's still hard, but we keep moving ahead and we use these tools, and you know, this advice and insights are so helpful to always have, and giving people grace is so true and so needed.
Yeah. And by the way, I think some of you know, I do a mini brief every morning, every Monday. I put out a little bit of information. If anybody wants to be on that mailing list, send me your emails too, and I'm happy to put you on that.
Awesome. I want to get all your information, and I know a couple of people already have questions about like the best way to connect with you. So just to wrap up in terms of our side of things, if you've attended this webinar, you are entitled to 25% off all plans, push Kaya push. If you're an existing client and you'd like to upgrade, you will get that discount. Or if you're a new client, just join the demo and let us know that is where you are finding the discount from. And like Beth was saying, we do offer HR tools to help with hiring. So the Great Resignation is something that we're really focused on as well right now. Applicant tracking is a really helpful way to help hiring, and then onboarding and time tracking and attendance. And I know there's also a couple of questions, and Beth is also aware of how kind of the software can help with managing these labor laws and things like that. So I'm just going to get into the question answer section as well. I'm just going to, so the first, so type your questions into the question answer section here, and we're going to get to as many as we can. And I know that there are so many. I already have one. So the first one I wanted to cover, Beth, is just the best way for people to connect with you in terms of your updates and getting your advice and all the good insights that you have. What's the best way for them to?
Yeah, if people want to send me their emails, I'll put them on my mailing list. That's probably the easiest way.
Perfect. Okay, perfect. Awesome. And then we already have a question here. Oh, we've got a few questions already. Okay, so can you repeat the requirement to show COVID sick pay on pay stubs and how that works?
Right. So the COVID, so unlike in the past where you were supposed to show the amount of COVID pay they had left, under 2022 rules, they want you to show how much COVID pay the employee has taken to date. So if they haven't taken any, you just show a 0. Otherwise, you show how many hours they've taken to date.
Awesome. And the next question is, where would I go to stay on top of all this information?
Well, you know, it would be wonderful if there's like one place that has like all the laws, and, you know, in California, there's not. It's like there's the labor code, there's a federal employment housing code, there's, you know, there's a bunch of different things. Obviously, we do try to really keep everybody, like I said, that's why if you want to subscribe to, we do a lot of alerts, and I'm now doing a briefing every Monday. And I actually, my Monday morning briefing is also in like a mini micro site. So there's like a little blog site you can look at, which is mondaymorningbriefings.com, which has a summary of everything I've talked about this year, which is a lot of information so far. So you can always check on that, which will bring you up to date for a lot of this. And like I said, we do send out alerts all the time. That catches you up on a lot of things to start. You know, if you just want to read for fun, you pick up the labor code. But, you know, in California, it's tough. You know, there's not one central place. California Chamber of Commerce put out a lot of information if you like signing up for them. But like I said, if you want to look for free, I am doing my lion's share these days of putting out something every week on like just bits like this of what's going on.
There's so much to know.
It is. It is.
When you were saying there's 30 different types of minimum wage in California?
Oh yeah, depending on where you are. But it's one of the reasons that I really tell people you kind of have to need to work with. I remember I was at an event once and I was talking with an employer, and I said, you really need to work with an employment law attorney. And he was talking about the minimum wage being so high where he is, and he said, yeah, it's like blah blah blah. And I looked at him and I said, but you're not in Los Angeles. He goes, what do you mean? I said, you're in Calabasas. And he said, huh? And I said, you're in the city of Calabasas. You're not in the city of Los Angeles. He goes, but I'm in LA County. I said, no. That minimum wage is for the unincorporated LA County. I said, you're in the city of Calabasas. And his mouth just dropped. I said, have you been paying the city of Los Angeles as minimum wage all this time? Which at the time was about $2 more than he had to be paying. And he just looked at me and said, this is why you need an employment law attorney. You were paying the wrong minimum wage all this time. And he was out of control. I mean, he had been paying, his minimum wage had been too high for about 2 years. That's why you really need somebody. I mean, people think they can do this on their own, and he had like 100 employees he was paying too much to for 2 years.
Oh my gosh. Wow. And it's the things you don't know that you don't know.
The things you don't know. Yeah. I mean, look, he could be done things wrong, got him into a lawsuit, but he was just overpaying for 2 years.
Wild. Okay. The next question is, what are some ways that you can use tools or technology to help you not get a lawsuit?
Well, I mean, you're great at that. I mean, obviously we try. I mean, obviously I can try to invent Kender, but technology, if you use it correctly, is a great tool. And using it, for example, to track break compliance. I mean, that's one of the places I push people to all the time. I mean, I don't understand how people are still manually tracking breaks and not using it to pay the break premium. That's a no-brainer to me. Break compliance is such a huge area of problem right now that if you have people who are not, especially if you're in a high risk area like a restaurant, so you have a lot of employees and you have people who are working 5 hours and you don't know when that line's being crossed, that it's being flagged for a break violation, you're a sitting duck for that. I mean, people say, well, we have people who are manually going through, and I'm like, and I see your errors every month. I mean, like, why are you letting that be a manual issue? There's just no reason that should be a manual issue. You should have automatic break compliance. Then when you get a class action or something, I can say to them, they have this automated, and you know what? Their attorneys will just say, okay, and they will automatically throw that issue out. And for me, that is such of a game changer, because I know then that you will never have that issue come up in a class action or PAGA suit. And why would you live with that risk? It's just, that to me is, you sleep at night. Like I'm buying a new house and I'm getting insurance. I sleep at night with insurance. You sleep at night with that. Yeah. I don't know why you would ever take that risk. You make too much money to throw that stuff away. Why are you throwing away, between the technology and things like this, like class action waivers, whenever you can get them. Like we don't have that insurance yet with PAGA. Hopefully we will. But having technology handle that for you, that's the insurance.
There you go. That's so well put. Amazing. Well, I don't have any other questions for now. If you do have questions, everyone, feel free to send us an email. Check out mondaymorningbriefings.com, check out Kender. We will share the information on how to get on Beth's mailing list. And Beth, thank you so much for joining us and sharing all that amazing information.
Thank you, Stephanie. I hope everybody has a really great, and everybody keep your fingers crossed for Viking River Cruises. The oral argument is the 30th, I think. We'll be tuning in live for it. But check out my briefing and I'll be giving you an update afterwards. So good to see you all. Thanks for checking in.
Thanks, Beth. Take care.
All right, bye.
Bye.